وبركاته. أهلا وسهلا بكم في هذا اللقاء الجديد المتجدد من لقاءات الإيمان العامرة ولقاءات الحب والتبادل الفكري والثقافي والمعرفي. We are honored and delighted to have with us Prof. Dr. Naqib Muhammad Nasrullah, the Vice Chancellor of Islamic University Bangladesh. This is our Nadwatul Jumu'ah number 595. Although today is not Jumu'ah, however, it is conducted usually on Friday, 11 to 1. But perhaps sometimes because of certain circumstances, we change the date, we change the venue, we change the time, and also we change the day, so no problem, inshallah, as long as it is beneficial to us. To begin with, I will invite the HOD, Associate Prof. Dr. Sayyid Muhsin, for his 1 minute welcome remark. Inshallah, tafadhal.
السلام عليكم ورحمة الله وبركاته. بسم الله الرحمن الرحيم. الحمد لله رب العالمين. اللهم صل وسلم وبارك وزد على سيدنا محمد وعلى آل سيدنا ومولانا محمد. We begin this important session with Kitab al-Fatiha. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين. Respected Professor Dr. Naqib Muhammad Nasrullah, Vice Chancellor of Islamic University Bangladesh, our guest of honor today, and Associate Professor Dr. Abdul Hamid, the head of Nadwatul Jumu'ah program conducted by Department of Fiqh and Usul al-Fiqh, Professor Muhammad Kamalullah. He is our senior professor from the Department of Fiqh and Usul al-Fiqh, and today's moderator, Associate Professor Noor Muhammad Usmani, and other lecturers, students, brothers and sisters. Thank you very much for this gathering and your participation today. And Department of Fiqh and Usul al-Fiqh is, I would like to take this opportunity to welcome our guest to International Islamic University Malaysia, in particular Department of Fiqh and Usul al-Fiqh, Abdul Hamid Abu Sulaiman, Kulliyah of Islamic Revealed Knowledge and Human Sciences. And our guests will be talking an important topic, Sharia law integration into the legal system of Bangladesh. I think it is very related to the niche area of the department, because the department usually promote the research related to the contemporary juristic issues which have theoretical relevance and also practical importance. So I think this topic is, I'm looking forward to learn and benefit from the talk by our guest of honor. And I think Bangladesh, predominantly Muslim population, but adopts a distinctive dual legal framework based on the secular and Islamic principles. I think the history is very clear. I mean, before independence in Bengal and our areas, Islamic law was in prominence. Then by colonial rule, introduction of English common law. Then in 1971, Bangladesh independence, and 1972 the constitution. Now the secular, but there is a huge influence of Islamic principles on the personal law thing. So I think this is a very, very important topic, and this is a great addition to the Nadwatul Jumu'ah. Nadwatul Jumu'ah is a weekly program, and we are now in 595. We are looking forward the 600 to celebrate the 600. So we are very happy for your presence and the talks, and our university is really blessed with a lot of brothers and sisters from Bangladesh, including the staff and students. They are not only the part of IUM, but also significantly contributing to the body of knowledge, spirit, and unity. With that notes, again, I thank you for your willingness and readiness to share some of your knowledge related to this important topic. Jazakumullah khairan. Thank you very much.
Barakallahu feekum. Thank you very much, Associate Prof. Dr. Sayyid Muhsin, our HOD. Without any delay now, I pass the mic to Associate Professor Uthmani to moderate the session. Of course, he will be introducing the guest, Prof, the speaker, Prof. Naqib Muhammad Nasrullah. In 1 minute, 2 minutes. Are you going to read the entire series?
Inshallah.
Inshallah.
Less than 1 or 2 minutes.
And then, inshallah, we will have a Q&A session after the talk. Prof, would you like to have 2 hours, 3 hours? No? 40 minutes? 40 minutes?
We
50 minutes?
can go for 40
Inshallah,
minutes,
40
then
minutes?
Q&A.
Inshallah.
Okay, no worries, no worries.
We want to learn from you.
Yes, sir.
Inshallah.
Okay. Thank you, Prof.
Keep it open. One time.
Maximum 40 minutes.
As long as he wants.
Maximum 40 minutes because I'll be rather busy tonight. I'll be leaving.
Oh, I see.
Okay.
نعم. السلام عليكم ورحمة الله وبركاته. بسم الله الرحمن الرحيم. Welcome to this important session on Sharia law integration in Bangladesh, and this would be one of the great sessions, inshallah, to know about Islamic law and how it has been integrated. Today we have the guest of honor, a very special guest speaker from Bangladesh. He is the Vice Chancellor of Islamic University, Kushtia, Prof. Dr. Naqib Muhammad Nasrullah. He is the Vice Chancellor and he is the Professor of Dhaka University, and there is known to be Oxford of the East. And now he is serving as a Vice Chancellor to the university there. And there is the only public university we have in Bangladesh. We have some other private Islamic universities, but this is the only public university we have. Prof. Naqib Nasrullah, he is a graduate of Kamil Hadith first, and Kamil Fiqh, first class first. And then he shifted to Islamic law, law in general. And then he's a graduate of Dhaka University. Then he went to Australia, South Wales University there. And from there he got masters and PhD, alhamdulillah. And then after coming back from there, he was serving Dhaka University and also Islamic University both from 1994 until today. It is almost I think 31 or 32 years he's serving there. So without taking time, I leave the microphone to Prof. Naqib Nasrullah, inshallah. After he will take around 40-45 minutes, not more than that, inshallah, and then we will open the floor to the audience here, inshallah, so that you may ask any question related to Islamic law, about Bangladesh, how it is Islamized or secularized. Is it secular law is dominating or Islamic law is taking over? And how far the country has become Islamic? And what is the situation now, for example, today? All right, the microphone is for Prof. Naqib Nasrullah.
Bismillahirrahmanirrahim. Bismillahirrahmanirrahim. Do you hear me without mic?
It's all right.
Okay.
But we are recording
Want to
maybe.
record
for
it.
the
Oh, you are
purpose,
recording.
Yeah. Should be okay now.
Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. As-salatu wassalamu ala Rasulihil Kareem amma ba'd. Respected professors, researchers of this department, and especially the head of the department, the head of the schools. This is the head of the schools?
Head of the program.
Oh, head of the program.
And how the
And
department is
our department is there. and Professor Amanullah and Professor Usmani. So I'm enormously glad to see you all and being present here with few words on this issue. Indeed, it is not a scheduled program, although it has been scheduled before. But I came here accompanying my daughters who wants to study here in Taylor University, and she's my first daughter, and therefore I thought that I need to accompany her to Malaysia. This is after long years. I came first here in 2005 to attend a conference organized by the ICRC. Then it is my second time to come here, and on a day during my first visit, I came to the campus at night. I didn't see anything, so I was very much eager to see the campus first. But whenever Usmani told me that to make your presence to some extent the meaningful or useful, would you like to present any paper here? So or give any talk? Then I thought that what the area I can select. In fact, after being the Vice Chancellor of University, often I will remain engaged in many administrative activities, and wherever I find any kind of the academic activities, I try to attend. Usually I try to attend the seminars and all the programs related to academic affairs, academic exercises. So therefore, I didn't think that the university right now is closed. But whenever you invited me to give a presentation, I thought that university would be open. Nor is because usually I find in the Australian university when I studied there, especially the very important seminars is held with the few attendees who are the matured one. Now I think this is very matured. You are very matured one. You know more than me. Now I'm in fact the man of international law. My research and my academic exercises involve international affairs, diplomacy, international trade, human rights, etc. But as this is the Islamic university, so therefore I find it very much relevant, because as it is being held under the fiqh department to select this issue. And I have prepared some slides very hurriedly, and I would like to talk to you. I'll open the floor, then that would be very much useful to discuss among us. If you have any questions, I'll try to ask the questions. Okay. You all know the integration of Sharia law into national laws of Bangladesh. Bangladesh as a country is a democracy, having a secular administration, and it is a Muslim majority country, but Sharia law is not applied in major areas like in the personal lives, business lives, and the national lives, administrative lives, all these areas. There are many areas that we all know. Sharia law integration. There are certain areas where Sharia laws are integrated into Bangladeshi national laws. As we had been the colony of British for 190 years, therefore there had been many changes into our local and national laws, and currently it completely, in the majority sense, we follow the English common law, except if you where we find the integration of the Islamic Sharia law. And therefore the integration of the Sharia law into national laws of Bangladesh has been now in a position what actually took place during the British regime. And a certain development occurred during Pakistan regime. But after Bangladesh getting independent, we find no integration of the Sharia law into the national laws. So although we are independent country at this moment, but as I am saying that it is unfortunate that after 1971, there is no integration of the Sharia laws into our national laws. And to draw the background of India, the laws of Indian subcontinent, and I would like to focus on some historical background and the characterization of our national laws. The purpose of my talk is to examine and evaluate to what extent, in fact, the Sharia laws are integrated into our national laws. In what areas do we find that there are two big branches of the laws. One is civil laws and another is the criminal laws. Civil law includes all the contractual issues and also the business laws, business issues, and all the issues relating to the appropriation and distribution of the land. And criminal laws involves, you all know, all the issues relating to the crimes. And crime is related to human person and human property and human dignity and all other documents used by the public, used by the government. We have a penal law in Bangladesh that includes all these things. Apart from this, there are some other special criminal laws, and at the same time there are some civil laws, land related to the distribution, land related to the demarcation of the property, sale of the property, and business issues. So these are the two big branches of the national legal systems. And if we look at the character and the nature of Bangladeshi laws, so we find that the Bangladesh laws has a blended approach. It has combined both the common law system and to some extent it has integrated into the Sharia law. And aspects of the Sharia law are very much related to the personal laws. And also, therefore, today, as the chair of the head of the department said that they has referred to the constitutional issues, we will focus on the characterization of the present legal systems with the integration of the national laws and also the constitutional provisions in this regard. And there is some judicial interpretation here to apply the Sharia laws. Sometimes the Supreme Court invite the amicus curiae. They have also set up a amicus curiae for fatwa, like 5 years before, during the last regime. And there is some judicial interpretation in Bangladesh. And we also issue the contemporary debates on Sharia integration, because we know that there are different organizations currently in Bangladesh debating on the Sharia laws, because Sharia laws, especially the distribution of the property, that affects gender equality. So therefore there are some contemporary debates, and we also focus on some comparative perspective and the current challenges. And then I will ask you to suggest me for some reforms, and also I will place some possible reforms, and that's will draw a conclusions. So if we look back to the historical development of our legal system, we can start from the era of Sultanate. That era existed before Mughal period. Era Sultanate started from 1206, then ended with the assumption of the Delhi's governance by Mughal. And then the British, after the end of the Mughal system, for few days we find we had been an independent one. Then again we was actually decolonized by the English systems, the English colonized by the British. And so therefore, what is about during the pre-colonial period? We will divide what we had been in pre-colonial period and what we are now at this moment, after the getting independence. In pre-colonial period, that includes the Sultanate and Mughal rule. And during the Sultanate and Mughal rule, the legal system was predominated by the Islamic laws, especially in case of the personal laws, criminal law, waqf, and inheritance. And during the Sultanate, the judicial system was administered by Qazi and Muftis during the Sultanate. And then during the Mughal period, the same system existed, both the Mughal and the Sultanate rulers. Then during the colonial period, a terminology developed, that is Mohammedan law. Mohammedan law means, you all know that this terminology used by the English people. They do not pronounce Muhammad but Mohammedan. And then they invented, they produced a kind of law where there has been existence of or integration of the Sharia issues, and they use the terminology Anglo-Mohammedan law. That means the Mohammedan law will be in the form of English law. That means both the law will be there will be integration of the Muslim law into the British legal systems, and thus they codified the Islamic law. They codified some Islamic law and reinterpreted the Sharia laws. And in 1937, we find an act was enacted, that is application of Muslim personal law, that means Sharia law, 1937. This act mandates the common law codes to apply Sharia law. And with the adoption of this law, Sharia law became the Sharia law integration into the national laws covered only 5 things: marriage, divorce, maintenance, inheritance, and waqf. What is like for the application of Muslim personal law, that is Sharia law, Act 1937. This is the first enactment with which Islamic laws, Islamic personal laws, covering all these 5, integrated into the national legal system. This is the first integration. And during the Mughal period, if we look at, we find that the Islamic criminal law was in application, in practice. At the same time, commercial laws were in practice. But after that, during the Mughal period, during the British period, a separate penal laws were enacted in 1860. And also a procedural law was enacted then. It is completely a secular law. It replaced the Islamic criminal laws. And at the same time, the commercial laws. Commercial law is to be Islamic, commercial is to be followed to some extent, or to greater extent during Sultanate, both during Sultanate and Mughal period. And the commercial laws are replaced with English, the statutes, like we see in 1872. The contract law was enacted, and the act was titled the Contract Act in the Indian Contract Act 1872. With the adoption and enactment of this law, all the contractual issues like contract of marriage is to be regulated by this. Although we know the Muslim, the law, the marriage, Muslim marriage, the contract of the Muslim marriage that consists of the offer and acceptance like Ijab and Kabul. This Ijab and Kabul, there was no other single definition of the Ijab and Kabul, but it is to be and has to be in line with the definition of offer and acceptance as provided by the Contract of 1872. And likewise, sale of goods, like the laws related to Qanun al-Buyur. Sale of the act was adopted in 1930. That is the Sale of Goods Act. Another act, that is Partnership Act, was enacted in 1932. And there are some other business laws, the companies laws was enacted in 1930. All the acts relating to the business issues were the secular law and in line with the common law. And so if we look at the common law, the contract, we see that the Indian Contract Act is the in toto. You can say the verbatim expression of the British or English, the Contract Act and contract laws. So during the colonial period, the criminal laws and commercial laws were replaced by the English, the statutes. So let's come to the Pakistan era. Although Pakistan got independent in the name of the Islam, the Islamic, the people, the Republic of Pakistan, but it's very unfortunate during the whole regime of Pakistan, beginning from 1947 to 1961, only a single development took place with regard to the Sharia integration, and that is Muslim Family Laws Ordinance, which is a very debatable enactment because this ordinance brought about many changes into the Sharia principles. It focused on marriage, divorce, maintenance, and inheritance, and also the inheritance and the dowry. And after the independence of Bangladesh, there is no single enactment was made in Sharia issue. So the changes we have already of 1961. This, as I told you before, the Muslim Personal Application Act 1937. This act mandates the common law codes to deal with the Sharia issue over these five, as I told you before: marriage, divorce, maintenance, even the guardianship, the inheritance. And apart from this, we have a Family Codes Act. Before this, it was Family Codes Ordinance 1984. During the Ashad regime in Bangladesh, it was enacted. Afterwards, it was modified and amended. Right, currently we call it that family law codes with the same jurisdictions. It has jurisdictions of marriage, divorce, maintenance, guardianship, inheritance. Not only here the Muslim marriage, but the marriages of the citizens of Bangladesh. All the divorce, it has jurisdiction to deal with all these issues. Okay. As I wanted to talk about the Muslim Family Laws Ordinance. we all know that the Muslim law doesn't require any kind of the registration. Although the Muslim countries currently, and the Middle Eastern countries and African Muslim countries, the registrations of marriage matrimonial system has already been developed. So Muslim family laws ordinance, for the first time brought about a change regarding the registration of the marriage and divorce both. And registration is mandatory, and registration of divorce is mandatory. Is a mandatory. The funny thing is here, if somebody doesn't, if any marriage is not registered, so both the parties will face the judicial punishment, but the marriage will be valid. Marriage will not be invalid. Marriage will be valid if it is solemnized regarding the personal, as it is personal law. So marriage will be solemnized in line with Ijab and Kabul, and the presence of two male the witness, or one male and two female witness as per the Shariah. But if the marriage remain unregistered, the man will be subject to the punishment. The party will be subject to the punishment. In the same way, in case of divorce, the same principles will be applied. Registration of the marriage, the mandatory. Another thing is the restriction on polygamy. This is very interesting thing, as you all know, that the Islamic Sharia law recognizes, according to the Quranic verses, although there are many debates and the controversies whether four at the same time, whether a single one is more impressed. We are not going for that debate. But in Bangladesh, under this ordinance, there has been a restriction on polygamy. What type of restriction? Yes, a male is allowed to have 4 wives at the same time. But if a male want to remarries when he is within the matrimonial relationship with the previous one, then a kind of consent is required from the first one, or a kind of permission is required from a arbitration council consisted of 3 persons, where the chairman of the union will be the president, and 2 other members will be, one will be from the family of the male, and then another will be family of the female. That means from the family of the existing wife, one will be the member of this arbitration council, another will be from the male from the family of the male. So with the permission of this arbitration council, here we find a kind of the contradiction with Islamic Sharia law. Okay, so restriction on polygamy. So 4 wives. So there are many cases we find. It's quite obvious then the consent from the first wife is too tough and too hard. If consent is sought, but in some cases consent may be given. But here you find that the person who have no relation with the marriage, but it's quite a social issue. So whenever it is a application should be made, an application from the part of the male to the chairman of the council, union council, that I want to remarry someone beyond my existing one. I'm not going to divorce this one, but I want to remarry. Then the chairman of the union council will form a arbitration council, taking one from both the families. And these 3 persons will give the consent. Then the marriage will be valid. Valid according to this ordinance. Okay, according to this ordinance. And this is that what marriage is a very much personal thing. But we find here the involvement of the social issue. The why? The when this ordinance was actually enacted under a commission formed during the regime of Ayub Khan, the Pakistan President Ayub, he formed a commission on marriage and divorce. Marriage and divorce. And that commission proposed and drafted this ordinance. And finally it was approved and adopted. The commission said, yes, marriage is a personal matter. A person can have the freedom to marry and remarry. And that may go up to 4 at the same time, according to the Quranic principles. But marriage is not only a personal thing, the personal matter, personal affairs. Whenever somebody marry, then it says marriage is a personal institution, legal institution. At the same time, it's a social institution. You cannot remain isolated from other persons, from the influence of the society whenever you marry someone. So therefore, to establish peace in a family, it requires the consent of the others. So the first one can never raise any question that without the consent of mine and any kind of the social involvement, the second marriage, the second marriage was taken by someone. So it will help to establish social peace. And then question came, so whether this marriage it is exaggeration of the Quranic verses. We know there are a kind of principles we have developed in the legal system. That is, a supplement and complement. So one law is the basic law, and afterwards the many other laws could be enacted to supplement the previous one, not to contradict the previous one, to supplement the previous one, if any challenge came to forefront. So here regarding marriage and divorce, in the society, Indian society, especially after the Pakistan came into being, all these are actually the challenges in that society. Even during our society, marriage and divorce is quite a challenge. So it has been done on the basis of istihsal and istislam. And then ulama, it was actually, the commission was chaired by Alim Maulana Fazlur Rahman at that time, who was criticized immensely by other Qaumi ulamas that during that time, that a man, the ulama who contradicted Quranic principles, violated Quranic principles, but the reply came from them in this way, polygamy. Another thing is talaq, divorce. So regarding divorce, we know how the iddat will be counted, either on the basis of tuhur or on the basis of the menstruation, as a tuhur. But here, they say it creates a conflict, and the counting is very difficult. So expiration of the 3 months will be the basis for the counting of the iddah. So therefore, under this ordinance, this change was made, that after talaq, the iddah period is the expiry of the 3 months. Expiry of the 3 months. And regarding talaq and this act also establishes principles of reconciliation. Reconciliation. We know, according to the Shariah law, a male deserves the right to divorce. And in some cases, it could be delegate it to his wife. But here, before, if somebody wants to divorce his wife, and then a kind of the reconciliation, whether possible or not, so effort can be made to establish peace in the family at family level. So a divorce doesn't only affect the life of a husband and wife, but it may create a burden on other the family members and affect even the whole families. This is quite practical as we see. So therefore, the reconciliation of what we say that in Quranic verses, if the nushuz is created, so two members could be invited, called upon from two parties to settle down this. So they said that the reconciliation, the arrangement could be made, and it was codified into this ordinance. Another very important issue which is absent in Quran. We know the distribution of the property opens after the death of some persons. If nobody, the person whose property other will belong or inherit doesn't die, distribution will not be distribution. The share of the share of the predecessor, the successor will not be allocated at that time. But here, one thing we see, the doctrine of representation. You all are aware of this doctrine at this moment. It was introduced or established by this ordinance. That is the grandchild share. That means his grandfather is alive, the father has died. Under such a situations, how the grandchild will inherit the property of the grandfather. So doctrine of representation, the orphan grandchild are allowed to inherit from their paternal grandfather to stage. Although the grandfather is alive, that means the distribution of the property has not yet opened. Okay, so they are to inherit their father's property, but this ordinance established a principles, terming this principle doctrine of representation, allowing the grandchildren to inherit the property of their paternal grandfathers. And the share will be like the Quranic share. Share will be like the Quranic share. That is the Quranic share. But there was no mention of the Quranic share. But only was that they will represent their fathers. Okay, what share they will belong to, the father is to belong, they will go to their share, go to their property, add to them. So it is a kind of the departure, as we all know, from Shariah principles. And we see this is the exaggeration of the Quranic verses. And according to the usul, exaggeration of the Quranic verses is not permitted. And for first one, I'd like to say, there is, if somebody doesn't, like regarding the talaq, if somebody doesn't organize the reconciliation program and divorces his wife, not maintaining the principles of the idda as provided by this ordinance, he will be subject to the punishment, but talaq will be held or will stand. Talaq will stand valid. Okay. And doctrine of representation still in practice. And all the judicial interpretation here, that in Bangladesh, at this moment, the like Pakistan, the distribution of the property, deceased property, is actually governed by the courts. Courts maintains the share. Whenever somebody dies, a certificate should be achieved by the survivors from the Union Council, and it has to be submitted to the court, and then who will belong to what share is be directed by the court, not by ulamas or not by any other equation or estimation. Because here there is a question of, and waqf, the waqf is also regulated by the Sharia principles, but in Bangladesh there is an ordinance, and called Waqf Ordinance 1962, and there are some other regulations and procedures, and the charitable property, trust property under Islamic law is regulated by this Waqf Ordinance. Okay, and what we see that although Waqf is a matter which has emerged from the Sharia concept, but this two law has curtailed some autonomy of traditionally associated with Waqf property. Okay. Gender equality, concept of the gender equality, and our civil society in Bangladesh. Gender equality, we all know that the female individuals share the half of a male share from their ancestral their property. So here we have some civil society. They are advocating for gender equality principles and the women's rights, and also have proposed for even a unified legal systems regarding the successions of the deceased property. Okay, on the basis of human rights principles, on the basis of the principles of non-discrimination, and they also the debate on the polygamy and divorce provisions, and polygamy system and divorce provisions. And the interesting thing is here, you all are aware of the Convention on the Elimination of All Forms of Discrimination Against Women. Under Article 1, the discrimination has been defined. Accordingly, we find that even a personal matter, discrimination takes place, is not the permitted if any country becomes the member of the CEDAW. As a but the principles relating to treaty and the conventions, it is permitted. He said that there has been a scope of reservation. Although Bangladesh simply relying on some integrated Sharia laws, but Bangladesh put a reservation here in case of the distribution of the property. Okay, distribution of the property, and Bangladesh, they here maintain the Sharia principles of distribution of the property, where female, that is, will share the half of the male. Okay, so but in constitutional principles, what do we see? In Bangladesh, there are four basic and fundamental principles of our constitution, and according to that constitutions, the secularism. But at the same time, Islam is a state religion. The point of controversy here is this is a state principles of a state policy. Both the secularism and religion, the Islam as a state religion, both of them are the part of the principles of a state policy. and principle of state policy mainly provide the guidance for the prospective laws, how the prospective laws will be formulated or enacted. If we look at the secular laws, point of secularism, so all the law will be in accordance with the secular concept. And if we look at the state as the Islam as a state religion, at least the laws of Islamic laws, even like the Mughal period, the Islamic laws were applied to the Muslims, and Hindu laws are applied to Hindus. Hindu laws, even in case of the personal laws in Bangladesh, Islamic laws, Islamic personal laws are applied to Muslims. Islamic Hindu laws are applied to Hindus. But after it was the secularism was embedded into our constitutional principles long ago in 1972. Since then, ever since, there has been no amendment, no proposal that the laws will be secular. There are many secular laws. The laws are common laws are the secular laws. But after the declaration Islam as a state law, there has been no change into the legal structure where integration could be possible. But there was no attempt was made so far to integrate Islamic laws apart from these few 5 types of personal laws. 5 types of those. Even that separate Sharia code, as we see, Pakistan developed separate Sharia code. Even they also follow 1961 ordinance. Even in Malaysia, you have the separate Islamic code. But in Bangladesh, there is no attempt made so far by the Muslim government to establish separate the judicial system, and let alone the criminal laws, because the criminal laws are here in Bangladesh. Zola is criticized, like the Qasas is criticized by the civil societies, and there is no attempt. But we see, not even in our laws, but across the global legal system, especially in common law system, as well as in civil law system, applied in continental Europe and some other countries which were the colony of the continental, it is the influence of Islamic, the basic Sharia principle, the usul, influence of the usul, like in case of the equity, in case of the equity principles, the Sharia equity principles is being applied to many other laws, if we look at deeply into those laws. And in Bangladesh, there has been an attempt to balance between Sharia law and the religious law. So law is the fatwa, how fatwa would be. If fatwa goes contradictory with any set law in Bangladesh, the set law will prevail. But if it is absolutely on personal issue, then fatwa will be valid. Okay, so fatwa could not be made on on any kind of the preventive punishment like slugging for theft, okay, lashing for theft. But in Islamic issues, Sharia fatwa in accordance with the Sharia is applicable, is acceptable. Okay, so allies Bangladeshi laws, they try to create a balance between Sharia principles and religious, and then they believe in the religious freedom, and the religious freedom even, that in case of renunciation from Islam remains unpunished in Bangladesh. If somebody is converted to another religion, embraces another religion, remains unpunished in Bangladesh. And because it depends on the freedom of religion, because freedom of religion includes belief and non-belief even. Atheism is a part of the freedom of religion. And even in Bangladesh, according to 1872 ordinance, the marriage is all right. A Muslim can marry a Hindu according to 1872 ordinance, and that ordinance provides that if two the male and female want to marry, they have to renunciate their religion, then marriage will be valid. Like in Bangladesh, we see it is Firdausi Rahman, and she was Muslims, and her husband was Hindu. Like in Maharashtra, according to this the law, the marriage is valid. In Bangladesh provides the legality of this marriage. So, in conclusion, we can say that although Bangladesh is a Muslim majority country, but attempts are meagerly made there to integrate Sharia principles apart from these five, to integrate into the main the legal systems in Bangladesh. And still it is confined to personal affairs, 5 personal affairs. Okay, so our law has a blended approach. We follow common law and to some extent, personal affairs, Sharia law, and Sharia law is also as I told you before, the amended by the statutes. So we can say the Sharia law in Bangladesh is not the Sharia law, classic Sharia law. It is in fact the statutory law, not the Sharia law. And what could be the proposal from our part? If we look at Pakistan, look at India, still they follow the same Sharia principles according to 1937, but we do not bother for India. But Pakistan is separate, they have Islamized their laws, and they have the Hudu ordinance, Federal Sharia Code, Malaysian legal system, like civil and Sharia codes. So in Bangladesh, can take lessons from these two Muslim majority countries and can establish, they can try or make proposal for Islamization some areas of the knowledge, like even some part of the business, the issues, business law could be like Kitabul Buyuru, the principles of Buyur, sale of goods could be to some extent applied or integrated into the current legal systems. The funny thing is that the 1930, the British, the Parliament, they enacted this law, but not yet the attempt was made. Some few changes are made there, amendments are made there, but no effort was made there to suit these laws, the culture of the majority people here. Okay, so the culture and the customs of the majority peoples are overlooked here in Bangladesh, and there is no attempt for Islamization of knowledge. The ulama and others, they always raise their voice to Islamize the country on the whole. It's quite funny. It is rather impossible, I think, because it's a big challenge during the present era. But my proposal is, to some extent, if we find here there is a scope of Islamization, here there is the scope of integration of the Islamic principles, we need to undertake that effort, not on the whole, because it would be rather difficult to cover all. So thank you very so much.
Thank you so much.